Alright, draft for misconduct complaint against Cloyd Benjamin. This letter reports ethical violations committed by attorney Cloyd Benjamin while acting as prosecutor and assistant district attorney in the parish of Natchitoches. These violations were critical toward not only gaining advantage, but toward a prosecution victory that resulted in a 30-day jail sentence for a man who was denied a fair trial as a result of Benjamin's conduct. Consistent with the Louisiana legal ethics rules, Mr. Benjamin should be disbarred for these transgressions that are factually documented in this report. Background: the city of Natchitoches charged Travis Hines with one count of Lars 14108, resisting an officer by refusing to provide his name to police in the Natchitoches Parish Public Library on January 22nd, 2022. The charge was prosecuted by Cloyd Benjamin, Assistant District Attorney. The matter was in the court of Robert Owsley, who was elected and then took office his first judgeship on January 1st, 2021. This is mentioned only because it is crucial to this report, which details that Benjamin unjustly capitalized on Judge Owsley's inexperience, seeking to obtain a win rather than seeking to obtain justice. The dates are all 2022. Pre-trial hearing dates were February 15th, March 3 times, April 6th, April twice, and then post-trial hearing was May 2nd. We begin in the middle with a clear violation of ethics rules. March 21 hearing. March 18th, Benjamin filed a motion titled Motion in Limine to preclude publication of witness video and audio statements and for production in-camera inspection. In that motion, Benjamin described video and audio recordings of two witnesses produced by the Natchitoches Police Department without further description. Benjamin did not state how long he had been in possession of this evidence. On March 21st, 2 days before the scheduled trial, a hearing on the motion was held. In the hearing, Benjamin revealed for the first time that the evidence he held was two video-recorded police interviews of librarians Rosalind Parker and Carlo Jimenez. Benjamin also revealed, though not directly, that he had been harboring these two pieces of evidence for weeks because he didn't want Hines to publicize the videos. Benjamin sought a remedy that prevented Hines from having physical possession of the videos to prepare for trial. Prior to learning of the existence of these videos, Hines had been provided a one-page, 164-word statement of Rosalind Parker, dated January 25th, 2022. Parker would testify in trial that she wrote the statements because they had misplaced the first one I wrote. Jimenez, on the other hand, is purported to have never provided a statement of any kind before January 27th, 2022, and none was provided to Hines by Benjamin. In summary, the loan document regarding the Parker-Jimenez library duo that was provided by Hines was Benjamin was Parker's January 25th, 2022 second statement. Benjamin never provided Hines with the exculpatory information that a first Parker statement was purported to be misplaced. Furthermore, Benjamin would go on to continue concealing that fact from Hines and Owsley during the March 21st, 2022 hearing. We know now that 3 days after providing her 164-word second written statement, Librarian Roslin was recorded on video in a January 28, 2022 interview at the Natchitoches Police Department, and she provided 1,947 words of response. This is the equivalent of a dozen Parker statements. This detail is important as we assess Benjamin's conduct during the motion hearing. We also know now that the Parker video ran 27 minutes 47 seconds with 1,947 words spoken by Parker and 2,027 words spoken by the interviewer, Detective Perry. Not only was Parker's spoken words extensive, the video also revealed that the detective spoke more than the witness, including coaching Parker on the importance of components of her testimony in trial. Certainly, this video recorded spoken word of the detective was a compulsory production of evidence by Mr. Benjamin to Hines. The Jimenez video length was 16 minutes 23 seconds in the March 21st, 2022 hearing, in which Benjamin sought secrecy of the Parker and Jimenez videos. Benjamin made the following boldly untruthful representation to the court of Judge Owsley. The video contains nothing new. There's absolutely nothing new in the video. It is just a picture recordation of what he already knows that was already received by him. This just happens to be a video. Essentially, Hines has the information already. There has been no new facts that are in it. I think the two videos are not more than 10 minutes long. That librarian and the librarians have a right not to be on video because they just went to work and have to testify. So we would submit that it be done in a controlled environment. He can look at it and he can go about his way. We'd just like to produce it to him like that, and he can look at it. It's only a few minutes long. They're not more than 10 minutes long, and he can look at it and take whatever time he'd like in a controlled environment with some supervision and take his notes or whatever, and we come in here 2 days later and do our trial on Wednesday. Within the same hearing, Benjamin admitted he had been withholding the evidence because to have given it to him last week or to have given it to him cringed me. Additionally, in his motion, Benjamin wrote the audacious untruth. Defendant's video posted on his social media account typically conjures an average of 10,000 harassing, intimidating, and violently belligerent comments. Hines challenged Benjamin's misrepresentation 10,000 in the hearing, presenting truthfully that his most recent 20 videos had received an average of 354 comments. Thus, Benjamin was incongruent with candor by the factor of 28. Benjamin would go on later to present the court with not only misrepresentation of fact, but misrepresentation of law. Knowing Owsley was a new judge with no criminal trial experience and an incomplete knowledge about criminal procedure, Benjamin had an even greater obligation to justice to behave within his ethical strictures. Instead, Benjamin chose to make Owsley's inexperience his ally toward victory at the expense of justice, expanding his willingness to boldly prevaricate to the court. Focusing now on just the March 21st, 2022 hearing, by stating falsehoods to the court, Benjamin achieved his goal to prevent Travis Hines from being provided copies of the two videos. The court granted the motion, and Hines was sent into a separate room to view videos that he believed would be a few minutes long and contain no new information. Having set the stage, let's follow the development of Benjamin's lies to the court in that hearing. Benjamin, essentially what we're asking is this court, there is a video of witness testimony, or of the witness, what the witness said. The defendant already has a copy of the statement, but this was just the video version of it. Emphasis added when Benjamin uses a singular form, knowing there are in fact two videos, and you understand what they're asking for, right? What the state's asking for is to provide it to you, but not to let you to take it with you. That's what they're asking for. They're asking for your to be able to, in camera means that you would be able to inspect it sitting in your chair at the screen, to be able to look at it and review whatever video information they have. They have an obligation to provide that to you. Emphasis indicating the singular form, showing that the judge has accepted Benjamin's representation. Benjamin, we believe that what could be done is that we could make available the video. Now, I'd like to say the video contains nothing new. There's absolutely nothing new in the video. It is just a picture recordation of what he already knows that was already received by him. This just happens to be a video. I want to make it available to him, but for him to view it in a controlled environment where the marshals or someone are looking to make sure he's not recording it, and he can take notes or do whatever he wants to it. He wants to it. Essentially, he has the information already, but he has an obligation to see it. Again, there has been no new facts that are in it, but to have given it to him last week, or to have given it to him, cringed me, because I knew as soon as that happened it was going to be posted, and there would be a face to this lady and to these persons who are witnesses. Benjamin, that librarian and the librarians have a right not to be on video because they just went to work and have to testify. He can look at it and he can go about his way, but to give it to him on a USB is to post it all over the internet. And we would just submit that we'd just like to produce it to him like that. And he can look at it. It's only a few minutes long. He can look it and judge, is it one video or is it two videos? Benjamin, it is actually two videos. Judge, okay. Benjamin, two different people look at for whatever. I think they're not more than 10 minutes long. The judge made its ruling in Benjamin's favor. Judge, so what I'm going to ask you to do, what they have suggested, which is to take your time and to review them in camera, which means that you can look at them. After the ruling within the same hearing, Benjamin turns 180 degrees and spoke differently of the videos. Hines, is it verbatim of their statements? Judge, I have no idea. I haven't seen it. Benjamin, you'll have to watch it and see. Okay, because I have their statements, so I would compare. Benjamin, it doesn't really matter the comparison of it. Judge will submit that's a trial issue. That's not an issue to be in motion in practice. Judge, right. If there's something different on what they say or more expansive on video, which there likely is, because people tend to say more as they speak as opposed to what they write, that's a trial issue. Yeah, you could argue that. That's not an issue for a motion. Absolutely. If you feel that somehow the information's off, but I mean, you'll have their information by video. You'll have that statement, you'll have that transcript. So you can argue if you feel that somehow you've been misled. But I mean, you're going to, the other things is this, I'm assuming those people will come into court, so you have the opportunity to cross-examine them as well. I believe there's an additional, one of those comprises of a librarian that I was not familiar with, that the police department indicated to me was spoken to, and they did a recordation of a video. I don't think there is a written statement from that person, so that's what you have. And again, that's a trial issue, so it is what it is in terms of what it is, and that's a trial issue. The next exchange indicates that the court still believed Benjamin's earlier misrepresentation that the videos were accompanied by exact transcripts. I'm going to need verbatim everything that was said in the videos, at least Well, that's what you have. You'll have the video. Yeah, I know. You'll get to look at it. I mean, that's what the purpose of looking at the video is. You'll have the opportunity. Benjamin went on to make the videos a centerpiece in his trial presentation. Librarian Jimenez testified in great detail, clearly prepared for testimony by Benjamin, and countered to Benjamin's statement 5 days later that Benjamin was a librarian that I was not familiar with. The videos contained loads of new information that was vastly different and unmentioned in Parker's written statement. The video content was relied on and mentioned specifically in Judge Owsley's verdict of guilty, and Travis Hines was sentenced to 30 days in jail. It is notable that Benjamin did not seek the remedy of a gag order that might have been properly supported in law, even though that remedy would have achieved its purported purpose of protecting witnesses from harassment or intimidation. Such remedy would have been sufficient, but it would have also resulted in Hines having full access to the videos in order to prepare for trial, and even possibly to return to the court with the fact that Benjamin had lied in the March 21st hearing regarding the true nature of the videos. Benjamin instead shielded his lies from discovery, encouraging that the trial be held 2 days later. Based on only this single March 21st hearing and Benjamin's subsequently dependency on the Parker and Jimenez videos, in making his case, the result should be Benjamin's disbarment. The prescribed punishment, according to Louisiana legal ethics, is disbarment when a lawyer with intent to deceive the court makes a false statement, submits a false statement, a document, or improperly withholds material information, and causes a significant adverse effect on the legal proceeding. But we have only scratched the surface. In this letter we detail further deception and unethical statements of Benjamin, analyzing the transcripts of 5 pretrial hearings, a 7-hour trial, and 1 post-trial hearing. February 15th, 2022 hearing. Judge: in Louisiana, there is what they call open discovery. In other words, there is no Perry Mason moments, there is no surprises. You ask for what you want, he gets whatever you plan on presenting. This indicates that Judge Owsley misunderstands the discovery rule with respect to production by the state. The state is required to produce all exculpatory evidence, even if the defendant doesn't request it. The judge goes on to demonstrate that he does understand what's required of the defendant. He's only required to produce the evidence he is going to use in trial. Benjamin: Judge, I would like to go on the record. I've filed with the court a written response to Bill of Particulars, and this is the entirety of discovery, including all of the things that are being indicated here. My discovery is open. It's always been open. We don't hide the ball. Here it is. Judge: okay, so you have been presented with what he has deemed, Mr. Benjamin, on behalf of the state, has deemed to be all of the discovery, meaning all of the information they plan to present you at trial. Emphasis added. There is no doubt that these videos were only being produced to Benjamin's prosecutorial benefit. He needed to use them in trial. Had that not been the case, Benjamin clearly would never have revealed their existence. Hearings moment by moment. Is Cloyd telling the truth about why the courts don't even allow cell phones? If I may jump ahead, I have all this discovery here. Not true. Well, if he has anything, I want all the videos he has, all of the things that you have recorded in the library. They are all open to discovery because they are done in connection with the case and we have a right to them, so that's a start. You have everything that I have, and you have thumb drives, you have a police camera video, you have reports. They're all indicated in the Bill of Particulars if you'll look back, but you have several of those, but you have the thumb drive and you have an actual CD for which you can go and review on any computer or laptop anywhere. That's the totality of what the state has. So this document pretty much just calls into question the handling of evidence, on how prosecutors deal with evidence. They don't always disclose the evidence, but they will say that they did.